America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we begin, I have some housekeeping announcements. The First District Court of Appeals lets us use their facilities, so please respect their rules and have absolutely no food or beverages other than water in this room. Please silence your cell phones. Anyone addressing the commission, please speak up so recording equipment can pick you up properly. And my fellow commissioner members, please be sure to speak up into the microphone as well. And that those that are watching on our live stream can hear you. And members, we have a considerable agenda this time, so I'll ask that you please be as brief and concise as possible in your questions and comments. Pursuant to Section 286-0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission, other than in cases in which we act in a quasi-judicial capacity. That means the public can have input on matters other than complaints, opinions, and determinations of financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who is in the back standing. Thank you. All right, now we have the minutes of September 13, 2019. Can I have a motion? To approve.
Motion to approve the minutes.
Motion to approve. Do I have a second?
Second.
Motion approved by Commissioner Lesnoff, seconded by Commissioner Grant. Any discussion? All in favor signify by saying aye. Aye. Any opposition say nay. The minutes are approved. Next, we have item number 4, consideration of final action. In re Dennis McDonald, complaint number 16-062. Will the parties or their counsel please stand and identify themselves for the record?
Elizabeth Miller, advocate for the commission.
Thank you. I do not see the respondent present. This matter before us for a final hearing due to the administrative law judge of the Division of Administrative Hearings having relinquished jurisdiction to the commission for entry of a final order in conjunction with the advocate's motion to schedule matter, adopt ALJ's findings, recommend penalty, and render final order. Due to the proceedings at the division and the orders resulting therefrom, which have been sent to the parties and which are in your meeting materials, there appear to be no material facts in dispute, and the matter is postured for the commission's consideration as to argument on issues of law, argument as to whether the respondent violated the financial disclosure law, and argument as to any penalty to be recommended. We have copies of the relevant pleadings, orders, and other materials in this matter, and of a memorandum and draft final order from our staff. Mr. McDonald is not present.
He is not.
Thank you. Let the record show the matter was called up for consideration and that neither Mr. McDonald nor any counsel for him were present. Ms. Miller, you've identified yourself for the record. You will be given 15 minutes to present argument, and you don't need time for rebuttal.
Correct.
Commission members may raise a question at any time during the proceeding. The advocate may begin.
Thank you. Good morning, commissioners. This matter involves 2 allegations of failure to file an accurate CE Form 6. One was in 2011 and one was in 2013. In June of this year, the commission, wisely, I would say, rejected the party's stipulation of $250 civil penalty per allegation for a total of $500. The matter was referred to DOA for an administrative hearing. The respondent failed to participate in any of the proceedings, and the advocate submitted admissions to the respondent, which he failed to address or failed to respond to. Therefore, the administrative law judge admitted all the admissions. Therefore, it is my contention that there are no facts to be determined. There are no conclusions of law to be determined. That was all taken care of at DOA. The only matter left to resolve is the penalty. In this matter, due to the circumstances of this particular case, I would ask that a civil penalty of $5,000 per allegation for a total of $10,000 be imposed or be recommended by the commission. Also, a public censure and reprimand. Thank you.
Any questions by the commission? Commissioner Lesnoff.
Has there been a, I understand there were some complexities about this case. Has there been a penalty that high for a disclosure violation before?
May I?
Yes, ma'am.
Not that I am aware of, Commissioner.
Any other-
When you said circumstances, did you have particular circumstances in mind?
Yes, sir, I did, if I may. This particular respondent was very reluctant to participate, or actually did not participate in anything, and in fact made the whole circumstances a little bit difficult, I would say. And I think in this matter, his thumbing his nose, if you will, at the whole process warrants a higher penalty.
Any other questions by the commissioners? Mr. Anderson, would you like to comment?
Thank you, Chair. In this matter, it of course is a little odd from what we normally see, but of course in a civil context, failure to respond and an order that things are deemed admitted or proven can of course substitute for actual evidence and proof, and that's what we have here. And then the advocate did request a small amount of attorney fees and costs from the administrative law judge against the respondent based on the respondent's lack of cooperation in the whole DOA process. And so the final order that's drafted for your consideration, if you adopt it, and I would suggest that you do adopt the final order that I provided for you as a way to terminate the proceeding this morning, but it does provide that the respondent is liable for attorney fees and cost in the amount of $234, which was recommended by or found by the administrative law judge. That is not an attorney fee or cost thing that you normally see, like you see against a complainant, the normal thing. It's more of a generic thing coming out of administrative litigation. I'm not quite sure of the mechanics of how that would be handled going forward, but I think it was found. Nobody's contested it. I don't think we ought to disturb it. I think it ought to be a part of the whole package, and that's why I did include it in footnote 2 on the draft final order.
Any further questions? Commissioner Lesnar?
I have a comment. I was not here for the entirety of this case, and I understand that the respondent presented roadblocks and had difficulties. And I do think that the way in which an individual responds to the process gives us insight as to the motivations behind the behavior. And it is clear that this respondent had complete disregard for the law and for the process. Having said that, I think that we have dealt with matters that were far more severe with respect to their ethical violations and the nature of those ethical violations that have received a far less penalty. And so while I do think there should be an acknowledgement of his lack of participation in the penalty, I think this may be excessive. I'd like to hear from other commissioners, and I would have a motion at some point to recommend something as an alternative to the advocate's recommendation.
Commissioner Lesnar, I would suggest you go ahead and make your motion so we can discuss it then.
Okay. I would recommend that we assess a penalty of $2,000 per violation in addition to the attorney's fees and the public censure.
And adopt the final order and public report as
Yes.
otherwise stated.
Yes, thank you.
Okay, second. Motion by Commissioner Lesnar, second by Commissioner Carvajal to adopt the final order and public report, but to assess a fine of $2,000 per each violation. Is there any comment, discussion, questions?
I have a question. What is the maximum penalty under law?
Mr. Anderson?
Thank you, Chair. The maximum would be $10,000 per violation, so that could be a total of 20 in this case.
Mr. McManus?
Yes, I thought it was a bit high. Remember, the first time it was $250, and that was a settlement, was it not?
Correct.
And this commission rejected that respectfully. And then after that, apparently he defaulted. Is that right?
Yes, sir.
So there hasn't been a total disregard from day one. He was involved and he did have a lawyer, right?
If I may,
Yes.
he did not have a lawyer. He said that he did, but, and he told the investigator that he did. He sent a letter to the investigator that he would not cooperate with the investigator because he had a lawyer, but that lawyer would never file a notice of appearance.
Okay.
Any further questions, comments, discussion?
Madam Chair, just to clarify, which case this is, there was a related case also, right? Is this a spouse of somebody who also appeared before this commission?
Through the chair, yes, sir, was a spouse.
Just want to make sure I was thinking about the right one.
She was very cooperative.
Yes, Commissioner
I
Meigs.
I would disagree with this motion, and I would think we ought to follow the recommendation of our advocate. But, you know, it seems that what we have here is someone just totally thumbing their nose at this whole process. And, you know, I don't know if we need to send a message or not, but I believe this commission should be taken seriously, and this person obviously did not respect the courts, did not respect this commission, and had a wonderful opportunity, apparently, at one point in time to resolve this and chose not to. So I'm for sending him a message, and I think this is a good message, that the recommendation of the advocate.
Mr. Anderson, did you want to make a comment?
No, Chair, thank you anyway, though.
Commissioner Carbajal?
I think just to respond to Commissioner Meggs, I think we rejected the stipulation. So he did have a chance. He presented something, if I'm not mistaken, but we didn't think it was sufficient at that point. So even at that point, we thought that there was a need for a higher statement. It's not that there wasn't complete cooperation even back then.
Anything further? Seeing none, I'm going to call for a vote on the motion to adopt the final order, the draft order and recommendation with the reduced penalties to $2,000 for each violation from the recommended penalty of $5,000 for each. I'm going to ask for a roll call vote.
In favor.
Opposed?
Yes.
Yes?
No.
No. 4-3? Thank you. Thank you.
May I ask a question for clarification? Does that include?
Go ahead, yes.
Thank you. Does that include the attorney's fees?
It
And
did.
does that
The
include
yes.
public censure and reprimand?
Yes, the original
Okay.
motion did include that, I just didn't state it, yes.
Okay, thank you, Commissioners, thank you.
Madam Chair,
Yes,
we are in the posture of approving now the final motion, right?
I think that was the final motion, wasn't it? Yeah,
Through
we
the chair.
adopted the final order.
That's taken care of. What you did was you adopted the draft order with the modification of the monetary penalty amounts.
Next, we have item 5A, Henry Lynette Matheny, complaint number 19024, consideration petition for attorney's fees and cost. Ms. Mahaney's petition seeks to have the complainant, Mr. Donald Stroyer, pay attorney's fees and costs following the dismissal of the complaint against her. We have copies of the file in this matter and of the staff's draft of an order denying this request. At this stage, if the petition is denied, the case will be dismissed, but if the petition is not denied, the matter will be voted on as to whether it will be sent to the Division of Administrative Hearings for hearing. Are Mr. Matheny or Mr. Schroyer or their legal counsel present? So, all right, thank you. Our Executive Director, Chris Anderson, will summarize the staff recommendation on the petition, then we'll hear from the advocate. No, not on this one. Since there is no one present, for Ms. Mahaney or Mr. Schroyer. The parties will not speak, and the commission members can ask questions of Mr. Anderson. If you proceed, Mr. Anderson.
Thank you, Chair Rosanka. What we have here is these come up fairly common, but when somebody, a respondent, has had the end of an ethics case, then they have the ability statutorily to move for cost and attorney fees that they incurred in defense of the case, and sometimes beyond that. This is sort of an obscure request for attorney fees that was sort of buried in a response that the respondent made in the case, but in an abundance of caution, we consider this thing to be a request for attorney fees. But as the draft order that is submitted for your consideration details, the petition is lacking on its face as a matter of pleading, as a matter of law. I feel that it is not adequate and that it should be dismissed pursuant to the draft order and not be sent to the Division of Administrative Hearings. It does not have the content that the statute and the relevant rule require to go further and to have a hearing, and I believe you ought to just dismiss it by adopting the draft order. And if you have any questions, I'll try to answer them. Thank you.
Are there any questions for Mr. Anderson? Seeing none, could I have a motion?
I move to adopt the draft order as our order.
There's a motion by Commissioner McManus, second by Commissioner Lesnoff to adopt the draft order dismissing the petition. Any discussion? Hearing none, all of those in favor of the motion signify by saying aye. Aye. Any opposed signify by saying nay. Motion passes unanimously. Next, item 6, consideration of advisory opinions. We have 7 advisory opinions on our agenda today. File 2741 will be presented by Carolyn Klanke. Is the requester present? Would you please stand up and identify yourself?
My name is Amy Toman. I'm the Deputy City Attorney for the City of Thomas.
Thank you, Ms. Toman. Ms. Klanke?
Thank you. Good morning, Commissioners. Caroline Klanke, Commission Legal Staff. File number 2741 comes before you on an inquiry by Ms. Toman, who is the Deputy City Attorney for the City of Tallahassee. She is requesting this opinion on behalf of Form 1 filers who will be discussed in this analysis. As you recall, this analysis first came before you at your September meeting, but was deferred to be considered at this meeting in order to allow for additional time for consideration. In the interim period, on October 14th, the Commission received 2 additional questions, primarily pertaining to issues of valuation methodologies. The 2 additional questions are contained and addressed in new question 4 of this advisory opinion. Thus, the advisory opinion analyzes the requester's 6 hypothetical scenarios in 4 questions for your consideration today. All of the questions involve the city's appointed and elected public officers, as well as members of the city's leadership team who file financial disclosure accepting complimentary tickets to events. To be clear, the vast majority of city employees do not file financial disclosure, and so this analysis pertains to the universe of those individuals who are Form 1 filers or reporting individuals. In this analysis, they are identified as appointed and elected public officers within the city, as well as members of the city's leadership team. This is important because only those individuals that are reporting individuals, i.e. individuals who annually file a Form 1 or a Form 6, are subject to the additional gifts requirements which are analyzed with particularity in this advisory opinion and which are set forth in section 112.3148 of the Florida statutes. These additional gift restrictions largely fall into 2 categories. Prohibitions pertaining to gifts provided by prohibited donors, such as lobbyists, the partner, firm, principal, or employer of lobbyists, and vendors of the city, those gifts of which are over a certain threshold are prohibited from public officials who file financial disclosure accepting them. And the second category, permissible gifts that do not come from prohibited donors, which can be accepted in any value. However, if they are over a certain threshold, then they must be reported. In particular, under this bifurcated regulatory scheme, Section 112.3148, subsection 3, provides that reporting individuals are prohibited from soliciting from prohibited donors a gift of any value when the donor is a lobbyist, the principal partner firm employer of a lobbyist, or a vendor of the city. In addition, subsection 4 prohibits reporting individuals from accepting gifts from these prohibited donors when that gift has a value of over $100. Alternatively, under section 112.3148, subsection 8, reporting individuals may accept gifts of any value from non-prohibited donors, but if that particular gift has a value that exceeds $100, they must be reported. As a result of this bifurcated regulatory scheme applicable only to reporting individuals, the identity of the donor and the methodology for valuation of a gift is of paramount import in every factual analysis implicating this provision, and in every question that is before you for your consideration today. We wanted to, although the fact patterns before you are fact-intensive, and they are entirely hypothetical, we empathize with individuals such as Amy Toman, the requester here, who provide guidance to city officers on the political subdivision level. And so we wanted to afford them a roadmap. And that is what is before you today for your consideration. The 4 questions. Question 1 and question 4. These scenarios involve the city inquiring about when a third party, for example, a nonprofit, is hosting an event. As a predicate to the event, the city has purchased a sponsorship benefits package, which affords them an array of marketing benefits and event benefits commensurate with their sponsorship contribution level, gold, silver, bronze, for example. These benefits include advertising for the city, identifying the city as a sponsor of the event prior to, in media venues, and during, contemporaneously with the event, and a block of tickets to the event. Following the city's receipt of the sponsorship package, the city manager then offers the tickets at no cost to the recipients to the city's elected and appointed city officials and members of their leadership team on a first-come, first-served basis. First, the opinion in questions 1 and 4 provides that the complimentary tickets accepted by the city officials are gifts to the individual public officers who accept them, under the definition of gifts set forth in section 112.312.12a. As there is no indication in any of the factual scenarios presented that the ultimate recipients of the gifts, i.e. the public officers, have given any consideration of any kind for the tickets. As they constitute admissions, they are a gift. Thus, we must then identify the donor in such an instance, because we do have a gift scenario in questions 1 and 4. In questions 1 and 4, though, it is very clear that the city, as a predicate to receipt of the gifts, has paid equal or greater consideration. They have paid for them. And thus, in questions 1 and 4, the city is not a lobbyist, the principal partner firm of a lobbyist, for the purposes of their own employees and members of the leadership team and their own public officers. Thus, this opinion finds that the donor in questions 1 and 4 is the city. However, it is not a prohibited donor for the purposes of giving them a gift. Thus, even if the value of the gift exceeds $100, the city officials can accept them, and they can accept multiple tickets if they're so inclined. However, as these are permissible gifts, if their value does exceed $100, they will need to be reported under 112.3148 if they exceed the threshold of $100. Thus, valuation becomes of paramount import in the latter portions of these questions. In question 4, the request, or the latent filed question, the most recent one that's been added for your consideration, asks specifically whether portions of the sponsorship contribution package paid by the city may be deducted or backed out of the overall value of the sponsorship itself or the value of the tickets to reduce the value of the tickets such that they would not have to be reported. Or alternatively, whether a portion of the sponsorship contribution which has been identified as tax deductible for the city may be deducted ultimately from the value of the ticket to reduce the value of the tickets. For the reasons described in the opinion, both question 1 and question 4 advise that commensurate with the valuation requirements of section 112.3148 7K, the value of a complimentary ticket accepted by a reporting individual should be the face value of the ticket, or if no face value is reflected on the ticket, the published cost of admissions of persons with similar tickets. This has been the process with which we have derived valuation in prior advisory opinions, and we believe it is applicable in the instant case as well. Question 2. In question 2, the city asked whether tickets or admissions to VIP events or early performances which are not otherwise available to the public and given to city officials who file financial disclosure free of charge would be considered gifts. In this scenario, the city is the primary organizer of an event, but explains that other public and private entities are also sponsors of the event. The inquiry focuses upon those VIP tickets or early performances that the city provides or which one of the sponsors could provide, and which are generally not available to members of the public. Following the receipt of the tickets, as in questions 1 and 4, to the VIP events, the city manager distributes them to the reporting individuals on a first-come, first-served basis. Of primary importance in this scenario, given the array of sponsors, including the city, is the identity of the donor of the tickets to these VIP events. For the reasons described in questions 1 and 4, if the donor of the tickets is the city, the opinion finds that pursuant to the prohibited provisions of section 112.3148, the city would not be a prohibited donor of tickets or gifts to their own employees. And thus, the city employees could accept them. However, they would have to report them if their value exceeded $100. Conversely, the opinion explains that if, however, the donor of the tickets is one of the other third-party sponsors, the recipient, the donee of the ticket, must discern if the donor is a prohibited one, i.e. a lobbyist, the principal partner firm employer of a lobbyist, or a vendor of the city, or certain others. If that is the case, and the ticket value exceeds the value of $100, the public officer would be prohibited from accepting them. If, however, the value did not exceed $100, or the identity of the donor was such that it was a third-party donor but was not a prohibited one, then they could be accepted. However, they would have to be reported if the value exceeded $100. Question 3, final question. The city asks whether complimentary tickets to fundraising events provided by nonprofit entities that annually receive funding from the city and given to elected and appointed officials as well as members of the city's leadership team unsolicited are gifts. In this scenario, the opinion concludes that the tickets are indirect gifts from the nonprofit entities to the city official recipients. As such, the respective nonprofit is the donor for the purposes of the application of the gifts analysis. Therefore, as in with question 2, the donee, i.e. the recipient of the gifts, must discern if that particular nonprofit, that is the donor of the tickets, constitutes a prohibited donor, and if so, if the value of the tickets exceeds $100 under section 112.3148 subsection 4, they would be prohibited from accepting them. However, if that nonprofit is not a lobbyist, or the principal partner firm employer of a lobbyist, or a vendor of the city, then they could accept the tickets, but they would have to be reported if their value exceeded $100. Staff is available to answer any questions you may have.
Any questions, Ms. Klinke? Mr. Carvajal?
Probably have more, but particularly to question 3. The way, the opinion actually says that the nonprofit provide the tickets to the city and not the Form 1 filer directly. So, does the situation change at all?
Indeed, the situation does not change. They provide them to the city, but as you'll see from responses to requests for additional information, and in particular on page 25 of your backup materials, we have a indirect gifts rule, which contains an 8-factor test in Rule 34-13.500. And in that rule, it creates certain factors that, when present, make a gift provided to the city and then ultimately benefiting the reporting individual an indirect gift. For example, on page 25 in the requester's responses, it specifies that the funded nonprofit organizations typically identify the recipients to receive the tickets.
So it's
And those, and those recipients thereafter are afforded the ability to have them for free. And so in question
I don't have page 25, so, or I may not be seeing it somewhere.
Page 10 of the opinion has those 8 criteria too.
Let me get to the same page you're on so I can formulate my question here. I don't think I can.
Page 10 of the order? Oh.
Of the
Of the gift, of the proposed,
Of the amended?
yeah, the amended, yeah. I'm on, I didn't know if they were different, I'm looking at the amended as well.
there
Start
have
this in the
been, I
footnote.
apologize, there have been multiple
Does-
versions. of
Does
this
anyone need
analysis.
an extra copy of the amended? It's not in the computer.
Oh, yeah.
Do we have extra copies?
I have one additional copy.
I've got one here also.
I
Does
have my
anyone-
copy, so I think,
Carolyn,
Go
if anyone
see.
needs, have it.
Yeah.
I have my copy, so.
Yeah.
So may I clarify what you just, through the chair, said? The organization has provided it actually to the individual and not, for example, to the city manager, because it is designated to that individual. For example, another commissioner.
They provided the city manager with a block of tickets.
I see you answering a question, but I just, for the note, I see behind you that somebody is shaking their head no, so just wanted you to know that.
Do they go directly to the individuals? They do not. They go to the city manager and then are distributed to the individual? Yes. Yes, that's my understanding as well.
So why is, in this case, the city manager not the donor at that point?
Because he is merely a conduit. Indirect gifts are common where the ultimate benefit has been, is directed to and is ultimately gleaned by the reporting individual. There was never an intent for the city manager to be the ultimate recipient of the tickets.
And in the other 3 scenarios, it was. They were given as a package, basically, either because of the sponsorship of it. Okay. And I think I'm in agreement with everything that, I think you are agreeing to, but does the city manager not have a responsibility to block things from going past him or her to protect the others? I mean, maybe not ethically. Well, let's stick to ethics since that's our domain. Does the city manager not have an ethical obligation to make sure that nothing passes them?
He has no legal responsibility, but gatekeepers, including the requester here, help and facilitate compliance with the Code of Ethics by requesting opinions such as this, receiving guidance with respect to what they need to be cognizant of, how they can help facilitate compliance. He has no legal obligation under the statute. The statutes within the Code of Ethics apply only to the public officers and public employees, but this process of which you are a critical part helps them. And the indirect gifts rule is cited in its entirety in footnote 6.
Can I have my guide here? Through the chair, one more.
Yes, sir.
I think and this may be more commentary, but I don't know when we're going to discuss it. I think I'm less concerned about the elected official who has a responsibility at that point, but the employees of the city report to the city manager in this particular case. And I know that there is not, generally speaking, they wouldn't perceive undue influence necessarily. But if a boss says you're going to this particular event, does that change the scenario in any way in what you're describing here?
Well, the individual public officers and those individuals who file financial disclosure, they are the only individuals within the city's employ or service that file financial disclosure. And that financial disclosure requirement attaches to them because of the lofty perch wherein they find themselves. Most often because they have the ability to make decisions to commit public funds. And in question 3, they unquestionably have the ability to commit public funds annually to the exact people who are donating these free tickets.
Thank you. Thank you, Chair.
Commissioner Lesnoff?
In your question 3, the question was about a nonprofit receiving funds from the city. Under what scenario is that nonprofit not a vendor? I presume there's a contract, the city is buying service.
That's why the hypothetical nature of the question requires an answer in the alternative which is present. The definition of vendor, which is contained in section 112.3148, provides that it is broad. It is a representative of a business entity that is selling realty goods or services to the agency. However, there could be purely gratuitous grants of funds, for example, that we've seen when a city provides funding to a nonprofit, wherein it is not on a service-based concept. It is purely to support their ultimate nonprofit purpose.
Yes, Commissioner Lesnoff.
I know the question wasn't asked, and I don't know whether it would be appropriate for us to discuss or to caution against. The thing that caught my attention, in your first scenario, the city is actually purchasing a package, and so the city owns that and distributes it. Is the value, do we know that the value of what they're paying for is appropriate? So if they're buying, I'm gonna buy a sponsorship for $1,000, but the face value of what I'm getting in that sponsorship is worth $10,000, would that change the nature of what we're doing if they're paying less than an appropriate value for what they're getting?
That is an excellent question. We did make sure in all these scenarios that the city is certain that it has no solicitation component to any of these inquiries. And so there is no give and take with regard to the negotiation of the amount provided in questions 1 and 4. It's set by the actual conference organizer themselves. So that is fascinating, though. It could very well change the analysis if it were, say, a sweetheart deal.
Yes, and forgive my cynical nature, but these are events and parties that are going on between entities, and I could very well see sponsorships that are undervalued in an effort to sanctify buying dinners and events for folks who give you money.
Any other questions of Ms. Clanky? If not, could I have a motion?
Move to accept the proposed answer to the questions 1, 2, 3, and 4.
Do I have a second on the motion to accept the advisory opinion file 2741? Okay. Is there a second to the motion?
I would second.
Okay, so I have a second. Now, if it-
I would propose an amendment that supports the opinion, but also to caution, to ensure that the value of the sponsorship purchased is commensurate with the value of the events, dinners, et cetera, however that might be worded, to ensure that the city is paying the correct value for its event.
Absolutely, we can absolutely add that.
Commissioner Meggs, is that fine with you?
I will accept that.
Commissioner McManus and Meggs, excuse me. Any further discussion? Yes, Commissioner Calverhall.
Thank you. In discussion, I think the questions were answered very well and covered a number of different scenarios, but it is a situation fraught with too many hypotheticals, and I think the core of what we would try to get at up here is, it is actually great when elected officials and other VIPs for communities are attending events, and there's high value to both the city and the participant. But ethics requires a little bit more than even your fine writing can cover, and I think what Commissioner Resnick is trying to get at is the awareness of the context of everything we're doing, from the values of the tickets to the appearance. I don't think that we're trying to prevent community leaders from being community leaders, but there are hypothetical communities that we are close to that have fallen into disrepute for some things like this, and I think that we're not trying to condone that behavior by delineating it. I think that there's a smell test that must be passed.
Any further, Mr. Meggs?
Just a question, and I don't know who would answer this. Having had to attend certain events like this, what kind of event gives you a ticket that has a value of over $100? What are we talking about in this?
The valuation provisions of 112.3148 subsection 7, for the most part, are always per occurrence, with certain limited exceptions. Consecutive nights of lodging and tickets. So if a public officer were to receive, say, 4 tickets, say they responded to the city manager in question 1 and said, I would like to take my spouse and my 2 children to the event. Those 4 tickets, once received by the public officer, would be valued at the time of receipt, the face value of the ticket, or admission to comparable individual access, times the number of tickets. So if you had a $50 ticket, if you accepted 1, you'd have no reporting requirement, and you would have no prohibited gift issue. But if you accepted 3, you would very much have to be cognizant of the analysis that's present here.
Any other questions, comments, discussion on the motion?
We never had a second
Yeah, we did. Commissioner Meggs seconded.
on the amendment.
Yeah, he did. He accepted as well. Okay. All right, motion by Commissioner McManus, a second by Commissioner Meggs, with the caveat by Commissioner Lesnoff. All in favor signify by saying aye. Aye. Any opposed signify by saying nay.
Nay.
Commissioner Gilzine opposes the advisory opinion, but the motion passes. Next, we have files 2748, 2749, 2750, thank you, Ms. Tillman, for appearing. 2751 and 2752 will be presented by Mr. Anderson. Is the requester present? Thank you. Mr. Anderson.
Thank you, Chair Rosanka. I can't really take credit for all the good work in these. This is Ms. Ramming, who was with our office and left on very good terms, a fine attorney, and she did the bulk of the work on these. If, with the permission of the chair, I would speak to all of them together because they are essentially the same. The City of Jacksonville, their legal folks are very good at putting together detailed inquiries with lots of information in them, and we always appreciate that. And because you have the different people here, it had to be set up as 5 different files, but essentially it's the same question. And the answer is pretty straightforward and fairly simple, notwithstanding that there had to be a number of background facts submitted and then a good bit of writing in the draft opinions. But in essence, what you have here is there is an opioid abuse task force that was created by ordinance in the city of Jacksonville. And the Code of Ethics has recognized for many years that statutorily and expressly that sometimes you can have a situation where you would meet the facial elements of a conflicting provision of the code by a public officer, and these opioid task force members would be public officers holding employment or a contractual relationship with a business entity, which could be a nonprofit or for-profit hospitals, any types of businesses. If the public officer holds employment with that kind of entity or any kind of entity and the entity's doing business with the city, then prima facie that would be a conflict under the prohibitions of the Code of Ethics, mainly 112.313 subsection 7A. And that prima facie reality is present here. However, in that same section, 112.313.7B, there is an express exemption that is sort of wordy, sort of legalistic, but for many years the interpretation of it has been that if you have a statute or a special act or a local ordinance that purposefully infects the membership of a certain board with a certain type of individual, that essentially what you have is a waiver of what would otherwise be conflicting in favor of peopling the board with those with a certain expertise. And that's what we have here. And it's very clear from the local ordinance that the city has made a policy decision that they desire to have like an emergency physician, first responder, mental health treatment people, all these different routes of affiliation for these individual people. And it looks real clear that that's what's operating here is basically an exception to the prohibition on purpose to gain their expertise. And so therefore the draft opinions find that there would be no conflict for these folks to hold these employments with these entities that have the interface with the city, because it's all out in the open. It's been done under the statute. And it makes sense, frankly, that when you're talking about opioid abuse, you would like to have on your task force people that know something about public health and medicine and those sorts of things. And so these are all offered for your consideration. And if you have any questions, I'll try to answer them. Thank you.
Thank you. Commissioners, any questions of Mr. Anderson? Seeing none, could I have a motion to adopt these en masse?
So moved.
Who was, Commissioner Grant, moved to adopt Ethics Advisory Opinions 2748, 2749, 2750, 2751, and 2752 en masse, seconded by Commissioner Carvajal. Any further discussion? All in favor signify by saying aye. Aye. Any opposed signify by saying nay. They are approved unanimously. Thank you, Mr. Anderson. Next, we have file 2754, will be presented by Mr. Schaefer. Is the requester present? Yes. Could you please identify yourself? My name is Mel Black. Thank you. Mr. Schaefer.
Thank you, Chair. Commissioners, this opinion request concerns the recent constitutional amendment that you approved the implementing rule for in July. Now, for the benefit of Commissioner Gilzine, who is not here in July, I'd just like to take a minute and just review the amendment and the rule for you. The amendment is now found in Article 2, Section 8H2 of the state constitution. Prohibits a public officer or public employee from abusing their public position to obtain a disproportionate benefit for themselves, a spouse or a child, or a business in which they have an affiliation that's enumerated in the prohibitions language. If you remember, the Commission was asked to engage in rulemaking to clarify what was meant in the prohibition by the term disproportionate benefit and to set out the requisite intent needed to constitute a violation of the prohibition. In July, you all approved Rule 34-18.001, which addressed those two concerns. The rules submitted to the Department of State, and they became effective on September 30th. So that's the background. This request has been brought on behalf of the Board of Supervisors for the Bay Laurel Community Development District, the Bay Laurel CDD. They inquire how they should govern their behavior under the constitutional prohibition regarding two upcoming votes that they face. In particular, they inquire whether they could be found in violation of the prohibition, even if they fully comply with the voting conflict statute, as well as with all their ethics statutes and laws governing the operation of CDDs. Now, there's two votes in question here that they're asking about. The first vote apparently will occur at an upcoming meeting. It authorizes payment to a local developer to dispose of some byproducts that result when the district treats wastewater. One of the board supervisors is employed by this developer. Another supervisor is an owner at the developer. And they inquire, assuming they stay within the boundaries of the voting conflict law and all of the applicable laws and ordinances, if they could be held in violation of this new prohibition. The second upcoming vote is about approving water and wastewater rates for district customers. 3 of the supervisors are district customers, and they too ask how the amendment should be applied to that vote, assuming that they stay in line with all applicable laws and ordinances. So essentially, the supervisors are asking about these two votes, if the constitutional prohibition will be triggered, assuming they stay in full compliance with the Code of Ethics, Chapter 112, and with all other statutes and ordinances that are applicable to them. Now, the draft before you recommends you find the prohibition will not apply in these circumstances if the supervisors remain in full compliance with the laws governing their behavior. And the reasons why are taken right from the language of the constitutional prohibition and from the rule that you adopted. First, if you look at the language of the prohibition, which again is found in Article 2, Section 8H2 of the Constitution, it says it won't be triggered just because a public officer or public employee receives a disproportionate benefit from some public action they take. No, according to the prohibition, the officer or employee must have abused their public position to obtain that disproportionate benefit for the prohibition to be triggered. So it seems that both disproportionate benefit and abuse must be present for a violation to occur. So therefore, it seems that as long as an officer or employee is acting in full compliance with the Code of Ethics and all their statutes and laws that govern their behavior, an abuse doesn't seem likely to be found. Now, if you look at the rule, in the rule you define a disproportionate benefit as a benefit or result inconsistent with the proper performance of one's public duties, and you say the intent needed to violate the constitutional prohibition is that the officer or employee has acted with a wrongful intent to obtain a benefit or result inconsistent with the proper performance of their duties. So again, as long as the officer or employee is acting in conformity with their public duties, meaning conformity with Chapter 112 of the Code of Ethics and with Chapter 190 that governs CDDs, seems any result arising from their conduct can't be said then to be inconsistent with the proper performance of their duties, so it doesn't seem to be able to form the basis of a violation. Now, the draft does caution the supervisors not just to comply with the laws governing CDDs, but to also make sure their conduct is in compliance with the Code of Ethics. For example, it warns the supervisors not to take a bribe when carrying out their duties, because in that instance, even if they're technically in compliance with the laws governing CDDs, they could be held in violation of the Code of Ethics and possibly even this new constitutional prohibition. The rest of the draft talks about the similarities and differences between the constitutional prohibition and our existing misuse statute. I think that part of the opinion is fairly self-explanatory, but I can give you more detail on it if you wish. The requester's attorney did call yesterday with 2 minor factual corrections that I would like to be able to make in the final draft of the opinion. They don't change the analysis or the recommendation. The first is just to clarify the board meets every other month instead of monthly. And the second is that one of the supervisors is not just an employee of the developer, but also has an ownership interest in it. Again, I think those are just cosmetic changes. They don't change my recommendation. I offer the draft now for your review, and I'm happy to answer your questions. I know that Ms. Lightman is here as well if you have questions for her. Thank you.
Questions of Mr. Schaefer? would the requester like to speak? Thank you. All right. Seeing no questions, could I have a motion?
I will move to approve the,
Thank you.
Second.
I have a motion by Commissioner Meggs, second by Commissioner Manis to approve the draft advisory opinion, file 2754. Any discussion? Seeing none, all in favor of the advisory opinion signify by saying aye. Aye. Any opposed signify by saying nay. Motion carries unanimously. Thank you for attending. Next, we're on item 7, consideration of financial disclosure appeals. The agenda consists of the appeals of automatic fines under the financial disclosure law. There is no appeal in which the appellant has asked to be heard, thus we will take up the no hearing appeals. Are there any that you would like to hear individually, or may we take these up en masse, commissioners? All right. Seeing none, could I have a motion?
I move they be approved in bank.
Thank you. Motion by Commissioner Grant. May I have a second? Second by Commissioner Lesnoff. Any discussion? All in favor of the motion to approve? At the same time, please signify by saying aye. Aye. Any opposed, signify by saying nay. Motion passes unanimously. Next, item 8, consideration of second order on request for extension. There are 2 of these. They are requests for extensions to file disclosures. They are self-explanatory from your written materials. There are no questions, or if anyone wants to take them up separately. If not, may I have a motion?
move we grant the extension.
Thank you. Motion by Commissioner Meggs. May I have a second?
second.
Second by Commissioner Lesnoff to grant the 2 extensions.
Madam Chair, just to clarify, that's Bill Steele and Joseph Scheller, right?
Yes, sir.
Thank you.
Any discussion on the motion? All in favor of the motion to grant the extensions for Mr. Steele and Mr. Geller signify by saying aye. Aye. Any opposed signify by saying nay. Motion passes unanimously. Now on to item 9, consideration of order and request for extension. This is another Bill Steele, at a different file number, 19-16. Self-explanatory from your written materials. Do I hear a motion?
I move to grant the extension.
Motion by Commissioner McManus. Do I have a second?
Second.
Second by Commissioner Carbajal. Is there any discussion? All in favor of the motion signify by saying aye. Aye. Any opposed signify by saying nay. Motion passes unanimously. Now on to item 10, consideration of organization and operations statement. Mr. Anderson will go over this item briefly and take your questions.
Thank you, Chair Rosanka. This is an item that does not come up every year. It just comes up from time to time. It's required that each agency have something on their website that basically talks about how they operate and who you contact for different things. The primary reason that we're having one now is because since I'm now the executive director instead of Ms. Doss, that her name needs to come out of the statement and mine needs to go in there. And what we've done also is just have kind of a little bit more brevity in some of the statutory citations and things that are in there, but essentially, this is just a roadmap of how the commission operates. It's for public consumption, very useful thing, and it just is sort of a housekeeping update of it. Nothing major has changed in it, and it would be offered for your consideration for adoption, and if you have questions, I'll be happy to try to answer those.
Just a comment.
Yes, Commissioner
It
Grant.
was very helpful for me, and I thought it was very, very well done. I printed it out so I can carry it with me with all my ethics files, and I learned a lot. I think it was very comprehensive, and I applaud the staff for putting it together.
Any further questions, comments? May I have a motion?
Motion to approve the memorandum is submitted.
A second?
Second.
Motion by Commissioner Lesnoff, second by Commissioner McManus. Is there any discussion? Seeing none, all in favor of the motion signify by saying aye. Aye. Any opposed signify by saying nay. Motion carries unanimously. Thank you, Mr. Anderson. Next, we have consideration of expenditures, item 11. This is a request by our executive director for spending authority that will exceed his default authority of $10,000. We will explain the request, and we vote on whether to authorize him to be able to make the expenditures. This matter concerns the purchase of laptop computers for members and staff, and you have written materials on the matter in the file. Mr. Anderson.
Thank you, Chair Rosanka. The computers we've had for a while, and I understand that in January of 2020, the security support and other things are going to lapse for those. And so this is a matter to get new computers for members and several for staff. And it's kind of just what it is. I mean, I think we do need them. And there's a memo or an email from the folks, the technical folks that support us, talking about this in more detail that's in your materials. But because it is over a certain amount, the commission does need to approve it. And I would ask that you do give me that approval. And if you have any questions, I'll see if I can answer them.
Mr. Anderson, does that mean these will go away? Some will, some won't.
It could be a mix, through the chair, it could be a mix of while of what we have in the armory, so to speak, but, you know, some people may still have the M14. Hopefully this will be the M16 that we'll be getting, or at least maybe the M1 and more useful. But there may be some hanging around for a little while.
Thank you. Any questions from the commission?
Yes. Is there any kind of competitive bidding process for this?
Mr. Anderson?
Yes, through the chair. My understanding is that this is not a competitive bid thing, that it is something that is sort of structured through the legislative computer folks that are our support people. And Ms. Blaze with our office and Ms. Stillman and others, we've negotiated or talked with the folks, and this is lower than it was to start with when they started talking about cost. And I think the cost per unit is less than the old ones that you have now. But there's not a technical bid that we're going to put out or anything. This is sort of in the pipeline of the required standard inventory, that the kind of thing you have to work with the system.
Are we purchasing these directly, or are we getting them through some other state agency?
Mr. Anderson?
Yes, through the chair. If you don't mind, Chair, I'd like Ms. Blaze to comment on that, because she's more into this than I am. Lynn, if you could maybe give us a little elucidation on that.
The Office of Legislative Information Technology Services?
So we can let them worry about the ethics of purchasing.
Through the chair, yes, sir. We feel like, you know, it's you know, legitimate under the way that the directives are coming about how I mean, we are an independent commission on our substantive function, but the commission don't necessarily is tied in a practical way to these purchasing matrices that originate beyond our control sometimes.
And Mr. Anderson, just to make sure, the total amount is $18,020, correct?
I believe that's correct.
That's in item 1 on your memo.
Up to that.
Up to that?
That's what they've told us is the exact price.
Okay.
Yes, Chair.
Thank you. Any further, Mr. Carvajal?
Just a question, because in the director's presentation, he mentioned that these computers are for the benefit of the commission. It's actually for the temporary use when we're here. We don't take them home for the most part, except for short-term basis.
Through the chair, well, whatever would work, but it would be similar to what you have now with the existing computers and the way that those are issued and taken back into the inventory.
I actually think I was clarifying to make sure that people knew that we weren't using these for our personal benefit for the most part, so that we don't have to disclose that ourselves.
Through the chair, if
Yes,
I
sir.
might, certainly, you know, these things are part and parcel of your job function. They're in no way a gift under any law that works. No more than your chair there that you're sitting in. Although it's a nice chair.
Yes, Commissioner Meggs?
I think Lynn and I will be opposed to this because I've just learned how to use it.
Any other comments from the commission? Are there any comments from the public? Seeing none, may I have a motion?
Motion to approve the additional expenditure.
Do I have a
Second.
Motion by Commissioner Lesnoff, second by Commissioner McManus. Is there any further discussion from the commission? Seeing none, all in favor of the motion, please signify by saying aye.
Aye.
Any opposed, signify by saying nay. Motion passes unanimously. Next is item agenda 12, reports. I have no report. Mr. Anderson?
If I might, Chair, if we could defer to the Deputy Director, Ms. Stillman, on the update on the electronic filing system.
Certainly. Ms. Stillman?
Commissioners, just briefly, periodically, we're going to update you on our new electronic filing system that we're working on that will go live in a few years. If you recall, at the last meeting, I indicated we were a little bit nervous that we didn't quite have our team members in place at the time we had hoped to. At this point, the news is great. Due to the very hard work of Danny Cobb with the Office of Legislative Information Technology, he's been our main point person. He has assembled what we believe to be a really great team of technical folks, business leads, and team leads to work on this project. They hit the ground running. They've read and reread the bill. We're going through things with a fine-tooth comb, and a lot of those technical things are getting started, and we're getting really excited. So things are moving forward, and we're looking forward to a lot of good things and reporting on that progress in the future.
Anyone have any questions? No. All right, thank you. Mr. Anderson?
Thank you, Chair Rosanka. Only thing I would add to my written Executive Director's report is that, like I mentioned, Ms. Ramming left our employ on very good terms, and she's a very good attorney. And we're now fortunate to have Mr. Zilkowski. Steve, if you would stand up for us. Steve Zilkowski. And Steve worked for us previously back in 13, 14, and 15, and did a fine job for us then. And then he was poached by the Commission on Human Relations and worked there for a while doing a great job for them. And then he was further poached by the Department of Corrections, where he served admirably. And after he was released from confinement, he decided he would apply for this position, and we're glad he's here. And prior to being in Florida, he has 12 years of legal experience in Massachusetts, or that's part of his 12 years of legal experience was in Massachusetts prior to coming to Florida. And we're glad he's back. Sorry that Deanna isn't with us, but glad Steve is back, and please welcome him. And he's just jumped right on things and has hit the ground running. Thanks, Steve.
Welcome. All right. We have finished our public session in record time, and I would entertain a motion to adjourn.
So moved.
All right. Without objection, we will adjourn. Question, can we start before 10 o'clock?
Through the chair, the executive session, I think if people are here, you could do that before 10 o'clock if they're here, because there's no prejudice and they're able to participate. Although I will say, Ms. Fulford, we do notice people for a certain time, do we not, for executives? So there might be some complainants and others that might not be here until 10 o'clock. Is that right?
Right. I think we have enough folks here to get started.
Okay. Does anyone have a need to take a break, or may we go forward with those that we can?
We need to clear the room.
We do need to clear the room,
we do
yes.
need to take a break.
Let's take a 10-minute break. So we'll start at 10 till 10. Julian, that wasn't actually a cue this time.
You're just now getting used to that one, aren't you?